Good morning. Welcome to the Pennsylvania State Ethics Commission. Under the rules, I have a couple statements that must be read. So I'll do that first. We welcome all guests, and we're ready to proceed. Pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to said executive session or at the next meeting thereafter. An executive meeting was held October 8th to review matters that are by statute 65 PACS 1107-10 and 1108A confidential, including the review of completed investigations for the purpose of issuing final adjudications, the review of a confidential opinion request, the review and consideration of applications for 90-day extensions of investigations filed by the investigative division, and the review of pending litigation. An executive teleconference meeting was held on August 12, 2013 to review matters that are by statute 65 PACS 1107 and confidential, including reviewing a confidential opinion that was previously issued at the July 9, 2013 executive meeting. An executive meeting was held on July 9th to review matters that are by statute 65 PACS 1107-10 and 1108AC confidential, including the review of completed investigations for the purpose of issuing final adjudications, the review of a confidential opinion request, the consideration of a signed reviewing commissioner's recommendation to terminate certain preliminary inquiries, the review and consideration of applications for 90-day extensions of investigations filed by the investigative division, and the review of pending legislation. Before I proceed, I want to advise everybody that Commissioner Bergen is participating by telephone, so once in a while you will hear comments from her. I also want to advise you that commissioners are assigned various cases, and each one of them may this morning be reporting on your case or the cases that we have before us. My opening statement is pursuant to Public Official and Employees Ethics Act 170 of 1978, as amended by Act 9 of 1989 of June 26, 1989 as amended by Act 93 of 1998. The State Ethics Commission is specifically mandated to hold at least 2 public hearings each year, of which at least one shall be held in Harrisburg and at least one shall be held in a location other than Harrisburg. That's why we're here, to specifically seek input from persons and organizations who represent any individuals subject to the provision of this act from other interested parties. We have placed on the agenda for today's public meeting a notice that the Commission will be meeting today in part to receive input or testimony of said individuals pursuant to the provisions of the law. As our previously published notice has indicated, the Commission will request copies of any statement that is presented. The individuals presenting statements before the Commission will be allocated 15 minutes in order to complete their statements. Statements shall be uninterrupted, except that such statements may be interrupted or terminated by the presiding officer if it is determined that the statement is impertinent, scandalous, or otherwise improper. Having said that, those that will be sitting before us, we suggest that you speak up because of the technology. Sometimes it works better than others, and so with that, we will proceed. Based on the agenda, the commission agreed yesterday that we would take some things out of order. There's a possibility that we may have to have some executive session. We don't want to request that you go in and out, in and out, in and out. So the first item of business this morning would be item 3, civil penalties, consent orders, and Judge Lewis has been assigned those civil penalties orders, and she will proceed. Thank you, Judge Lewis.
Good morning. There are 4 administrative penalty cases with proposed consent agreements for our consideration. The following 4 respondents are principals that failed to timely file a quarterly expense report for the first quarter of 2013 in their capacities as registered principals. The first, Rite Aid. Second, Pennsylvania Economy League of Southeastern Pennsylvania, LLC, doing business as Economy League of Greater Philadelphia, the Zoological Society of Pittsburgh, and number 4, the Pennsylvania League of Urban Schools. In each case, the parties are in agreement that the respondent's transgression of the lobbying disclosure law was negligent. All of the respondents have already filed their delinquent expense reports. The respondents are in the process of paying the agreed-upon penalties. Those who have not yet paid should be ordered to pay their penalties within 30 days of the issuance of the Commission's orders. Pennsylvania League of Urban Schools has agreed to terminate its principal registration statement within 30 days of the date of issuance of the Commission's order, and to refrain from registering as a principal with the Pennsylvania Department of State for a term of 3 years from the date of the issuance of the Commission's order. The parties are free to contract to such terms in a consent agreement. Based upon my review of the facts, I am of the opinion that the consent agreements are proper dispositions for the respective cases, and I therefore make the following motion. I move that this commission approve the consent agreement submitted by each of the following respondents and the investigative division, and enclose the following administrative penalties for the respondents' delinquent expense reports for the first quarter of 2013. Number 1, as to Rite Aid and the Pennsylvania Economy League of Southeastern Pennsylvania, LLC, doing business as Economy League of Greater Philadelphia, 1 administrative penalty for each respondent in the amount of $3,535 each. As to the Zoological Society of Pittsburgh, 1 administrative penalty in the amount of $3,030. As to the Pennsylvania League of Urban Schools, 1 administrative penalty in the amount of $1,515. I further move that the Pennsylvania League of Urban Schools be ordered to fulfill its agreement to terminate its principal registration statement within 30 days of the date of issuance of the Commission's order, and to refrain from registering as a principal with the Pennsylvania Department of State for a term of 3 years from the date of the issuance of the Commission's order. Mr. Chairman, that concludes my motion.
Thank you. Is there a second?
Second.
Second, Commissioner Caldwell. Any questions or comments?
Yes.
Commissioner Gordon?
It's not really a question, but it looks like we're handling these cases in a timely fashion now. Do we have something happening in the Department of State that's getting them to us?
Yes, we've reached some type of an agreement with the Department of State where they are getting the notices over to us much quicker so that we're able to send out notice letters. And even though there are 4 on this list, the number of delinquencies is really dropping, and we're getting much better compliance.
I have a question. Where does that money go?
This goes to the back to the Commonwealth General Fund.
Commonwealth General Fund.
Yes.
Any other questions, comments? If not, all those please indicate saying aye.
Aye.
Any opposed? Okay, those consent orders have been approved. That was item 3 on the agenda. Next item on the agenda, we'll switch to item 6, which is civil penalties orders. Michigan Court has been assigned a
We have today 2 cases of individuals who have not filed their financial interest statements for calendar year 2010. One involves a default order and one a consent agreement. And I'd like to take the default case of Robert J. Irie first. He was nominated by the governor and confirmed by the Senate to serve as a trustee of California State University. He was served a first-class notice letter in November of 2011, allowing him to cure the deficiency of not filing without penalty. He ignored that letter. He was served the second certified letter in January of 2013, allowing him to cure the deficiency without penalty, and he ignored that. And finally, Chairman Bolger signed an order to show cause against him. He has ignored that and still has not answered, and he has not filed his 2010 financial interest statement. In light of the foregoing, Mr. Chairman, I would move that this commission levy the maximum civil penalty in the amount of $250 against respondent Robert J. Irie for failing to file a statement of financial interest for calendar year 2010. Further, the respondent shall be ordered to file his statement of financial interest for calendar year 2010 within 30 days of the issuance of the commission's order.
Thank you, Commissioner Corrigan. Is there a second? Second by Commissioner Nick. Any questions, comments? Question.
Our material doesn't indicate what this gentleman's tenure was as a trustee. Was he there for more than, was he there for more than 1 year, do we know? And did he ever file a statement of financial interest? There's one in question. Was he only there a year and just didn't?
No, I think he had filed previously, but this year he had no.
Along that same line that Roger was talking about, since he didn't do this in 2010, have we followed up to see if he did it in 2011 or 2012?
This was the only notice that we had, the only non-compliance is this particular year.
Well, what I mean is we're on notice that in 2010 he didn't do it. So
We haven't checked to see if there's been a deficiency like in 2011, 2012.
we haven't.
No, we haven't followed up. We generally, once we get the notifications from the Office of Administration of the individuals who haven't filed, they go through their process first of notifying individuals, their appointees to these positions. They give them the opportunity to file. Once they haven't filed pursuant to OA's directions, then the matters come to us. We haven't received the 2012 yet, but I believe he did file for 2011.
Okay, that was the second question I had, Rob. This was the 2010 financial interest statement, which presumably is filed before May 1st of 2011. And here we are at the end of 2013 discussing it. Isn't there a more timely way to get these notifications from OA, or what's the reason for that?
Sometimes it's primarily a delay of OA providing us with all the documentation, and also they take their time trying to get compliance before they refer it to us. They prefer to try to get everyone, all of their folks to comply, and then it might take 6 or 8 months. Like, we sent our first notice letter back in 2011 to this guy, and it was ignored, and it took us a while to track down a good address for him to finally get it served.
Is there some way we can speed up the process?
Probably if we had maybe a little tightening up of our interaction with OA. It sometimes will take us a while to finally track someone down where they're located. And that's what I think happened here. We didn't know where Mr. Irie was located. And once we finally got the correct address, we got him served. I mean, there may be some things that we can do, but I'm not sure. If you can't find someone, and we have limited resources as far as being able, other than doing motor vehicle checks and Lexus checks, it's sometimes difficult to try to find where someone's located if they don't want to be found.
Okay. Okay, you've heard the motion in second, you heard the discussion. Any more questions or comments? Then all those in favor, please say aye.
Aye.
Any opposed? Civil penalty orders have been,
We have one more.
oh, that's right.
And the second case involves a constable named Jason Slider, and he did not file a financial interest statement for calendar year 2010 again. He received the first-class notice letter in September of 2011, allowing him to cure the deficiency without penalty, and he ignored it. He received the certified letter in December of 2011, allowing him to cure the deficiency, and he ignored it. The chairman issued a formal show cause order against Mr. Slider, and he ignored that and did not file an answer. To date, he has not filed his 2010 financial interest statement, as far as I know. And in this case, I guess because it's a consent agreement, we did not assess the full $250 penalty, but only a $150 penalty. And so, since it's a consent agreement, Mr. Chairman, I would move that we approve it, submitted by Mr. Slider and the investigative division, imposing the civil penalty in the amount of $150 for his failure to timely file a financial interest statement for calendar year 2010, and that further he be ordered to file his statement of financial interest for calendar year 2010 within 30 days of the issuance of this commission's order.
Okay, you heard Commissioner Corrigan's motion. Is there a second?
Second.
Any questions, comments? There's another one, Commissioner Corrigan, goes back to 2010. So. Any other questions or comments? If not, all in favor, please say aye.
Aye.
Any opposed? Now, the civil penalty orders have been approved. Next item on the agenda is item number 7. Under the gaming law, Ethics Commission has some responsibilities, and Commissioner Corrigan has been assigned that case, and will report. Commissioner Corrigan?
The requester is Mr. Adam Komorowski, and Mr. Komorowski presently serves as a Pennsylvania constable. He is also presently employed as a security officer with the Meadows Racetrack and Casino. He has been promoted to the position of assistant security shift supervisor at the Meadows, subject to approval of his application for a gaming level 2, a G2 permit. In conjunction with Mr. Komorowski's permit application, the Pennsylvania Gaming Control Board, Office of Enforcement Counsel, has requested that he obtain a determination from this commission pursuant to Section 1512A51 of the Pennsylvania Racehorse Development and Gaming Act, which we'll refer to as the Gaming Act, as to whether his service as a Pennsylvania constable would cause him to be subject to the restrictions of Section 1512 of the Gaming Act. The restrictions would only be applicable to Mr. Komorowski if his service as a constable would bring him within the definitions of the terms executive level public employee or public official as set forth in Sections 1103 and 1512 of the Gaming Act. Our meeting materials include all of the materials that have been submitted in support of Mr. Komorowski's request, as well as information provided by our chief counsel regarding constables. I would note that Pennsylvania courts have held that a constable is an independent contractor and is not an employee of the state, the judiciary, the county, or municipality in which he or she works. A constable does not act for or under the control of the Commonwealth or a political subdivision. Also, Pennsylvania statutes do not include constables among the elected officers of counties, boroughs, first-class townships, second-class townships, or third-class cities. Pennsylvania's first-class, second-class, and second-class A cities operate under home rule charters. In reviewing the status of constables under the Ethics Act, the Commission has observed that constables are officials of the Commonwealth and not of the political subdivisions in which they are elected. Constables are within the Ethics Act's definition of the term public official, and they are subject to the restrictions and requirements of the Ethics Act. I would also note that the list published by the Commission pursuant to Section 1512 of the Gaming Act has included constables as within the Gaming Act's definition of the term public official, insofar as they have duties and responsibilities relating to gaming issues or licensing. If we decide today that constables are not within the relevant definitions, then our list will need to be changed to delete the constables. Mr. Chair, I would suggest that at this point it would be an appropriate time for any interested parties to speak on this matter, on this case, and I do think counsel is here for Mr. Komorowski.
Thank you, Commissioner Gordon.
Good morning, ladies and gentlemen of the Commission.
We would like you to state your name, both of you, and for the record.
I'm Brian Benestad. I'm an attorney for Mr. Adam Komorowski.
My name's Adam Komorowski. I'm a Pennsylvania State Constable as well as an assistant supervisor at the Meadows Racetrack and Casino.
You're Mr. Komorowski?
Yes.
Okay, please be seated.
Thank you. May I proceed?
Yes, please.
Thank you for those comments, and we understand the concern that the constable would have to be removed from the list, but it is we are here to reiterate that it is our position that constables are not covered by the Pennsylvania Racehorse Development and Gaming Act, as they are not public officials or employee public officers or party officers under the definitions of 1103. The case law and the statutes do not trigger the act. There is no conflict for Mr. Komorowski to be employed as a court-appointed constable by Washington County and to serve as an assistant security ship supervisor at the Meadows, holding a G2 level permit from the Game Control Board. And there's no reason why he shouldn't be able to hold both positions. Additionally, one thing that was not mentioned regarding the statutes of some of the case law, that the state cannot even be held liable for the constable's actions under the theory of respondent superior. He's not protected by the state. He has to obtain his own insurance. So to say that he has to obtain his own insurance and pay for that, and he's not protected by the state, then he can't have another position in order to support himself, doesn't make any sense. So mainly we're here to reiterate what has been already presented in our brief to the Commission, that the Act does not apply to constables, but also to field any questions that you may have. Either I can answer them or Mr. Komorowski is available for questions from the Commission. And we request that his application for a gaming level 2 permit be approved, and he'll be able to serve as a constable and hold his position as an assistant ship supervisor, security supervisor at Meadows.
That conclude your remarks?
That does.
Thank you. Any of the commissioners have any questions for counsel or Mr. Komorowski? If not, Mr. Corrigan, would you proceed?
Okay, Mr. Chair, I have reviewed the facts and the relevant statutory provisions, and it is my opinion that as a constable, Mr. Komorowski would not be considered an executive level public employee or a public official, as the Gaming Act defines those terms. The Ethics Act has its own definition of the term public official, and there's no doubt that constables are public officials as the Ethics Act defines that term. And constables are subject to the restrictions and requirements of the Ethics Act. However, constables do not fit under the relevant definitions in the Gaming Act. The Gaming Act's definition of the term executive level public employee at section 1103 of the Ethics Act would not apply to Mr. Komorowski as a constable. Paragraph 1 of the definition would not apply because it lists other particular specific public positions that Mr. Komorowski does not hold. Paragraphs 2, 3, and 4 of the definition would not apply because constables are independent contractors and not employees. As for the definition of the term public official, set forth in section 1512B of the Gaming Act, paragraphs 1 and 2 of the definition would not apply to Mr. Komorowski because they list particular public positions that he does not hold. Paragraph 3 of the definition would not apply to Mr. Komorowski because the position of Pennsylvania constable is not a county or municipal office. In considering paragraphs 4 and 5 of the definition, the threshold question is whether Mr. Komorowski would fall within any of the categories of individuals included in those paragraphs. As a constable, Mr. Komorowski has not been elected or appointed to a department, agency, board, commission, authority, county, or municipality. As for whether Mr. Komorowski would fall within the remaining categories, having been elected or appointed to a governmental body, neither the Gaming Act nor the Gaming Board's regulations under the Gaming Act define the term governmental body. The Statutory Construction Act does not define the term governmental body. And the Ethics Act's definition of governmental body does not apply to this inquiry under the Gaming Act. There are no applicable Pennsylvania judicial decisions defining the term governmental body. However, there is a Pennsylvania judicial decision determining that the common and approved usage of the term body connotes plurality and does not refer to just one individual. That is the Ristow case. Our meeting materials include various definitions of various dictionary definitions that lead me to conclude that the common and approved usage of the term body refers to a group of persons or things and does not refer to just one individual. Since there is no applicable statutory, regulatory, judicially approved definition that would include an office or officer as a governmental body, I believe that for purposes of the Commission's duties under Section 1512 of the Gaming Act, the office of constable is not a governmental body to which a constable is elected or appointed. And having given that short analysis and comments, I'd like to make the following motion. I move that the holding of this commission in this matter be as follows. Based upon the submitted facts, Mr. Komorowski's service as a Pennsylvania constable would not bring him within the definition of the term executive level public employee as set forth in section 1103 of the Gaming Act, or within the definition of the term public official as set forth in section 1512B of the Gaming Act. And therefore, Mr. Komorowski would not be subject to the restrictions of section 1512A, A1, and A2 of the Gaming Act. I further move that the constable shall be removed from the list published by this commission pursuant to section 1512A5, 2 of the Gaming Act.
Thank you, Commissioner Corrigan. Is there a second?
Second.
Second by Commissioner Colfell. Any questions or comments for Mr. Komorowski, his lawyer? Okay. All those in favor, please signify by saying aye.
Aye.
Are there any opposed? Sometimes we make people happy.
Thank you very much for your time and attention to this matter. We appreciate it.
Thank you for attending and thank you for representing. Okay, that concludes that. Items 3, 6, and 7. Now we will go back to item 2. Commissioner Lewis, Judge Lewis has been assigned this case, and we will proceed.
Good morning. The pertinent facts concerning this advisory request are as follows. And this is an advisory request that has been submitted by, the requesters in this matter are Liesl Adam, Chair, and Daniel E. Standish, past Chair of the Pennsylvania section of the American Waterworks Association, which I will refer to as the association. The requesters ask whether pursuant to the lobbying disclosure law, it would be considered to be lobbying if the Water Utility Council, or as I will also refer to it as the WUC of the association, would provide written comment on a proposed regulation prepared by a Department of State Government during the public comment period of the proposed regulation. If so, we are asked to address the following additional questions. 1, what reporting would be required of the association for the time spent by the WUC members assisting in or preparing the public comment that would be submitted? 2, what would be the basis for the good faith valuation of the time spent by the WUC members? And 3, what other reporting, if any, would be required by the WUC members? The association is a nonprofit scientific and educational society dedicated to the improvement of drinking water quality and supply. Its members include representatives from utilities, private, public, and authority, as well as regulators, waterwork operators, and engineering firms. The association is a registered principal as defined under the Pennsylvania Lobbying Disclosure Law. It engages the lobbying firm of Gameric Government Relations, Inc. The requesters state that although it is not typical for the association to spend more than $2,500 per quarter on lobbying activities, such could occur on occasion. The quarterly expense reports of the association have included expenditures for monitoring activities as well as lobbying work, the value of awards, gifts, and expense payments provided to state employees or officials, and expenses incurred by members. The association's bylaws establish the WUC within the association. The WUC is comprised of 12 individuals who represent utility members and 6 individuals who represent non-utility members, with the latter including at least 1 representative of a state agency with regulatory authority over public water supplies. The purpose and responsibilities of the WUC include developing action programs to initiate, evaluate, respond, and comment on legislative, regulatory, and other matters that directly affect water utilities. The members of the WUC are not employees of the association and receive no compensation from the association. The 12 utility member representatives of the WUC are employees of the utilities that they represent, and those utilities are members of the association. As utility employees, the representatives are compensated by their employers for the duties that they perform for their employers, which the requesters state are non-lobbying duties. However, their duties include representing their employers on the WUC. The organizations represented by the 6 non-utility members of the WUC may or may not be their employers. The requesters state, quote, "It is reasonable to say that they are employed, are compensated by their employers, and attend the WUC meeting with the approval of their employer," end quote. The industry organizations represented on the WUC provide input to discussion and are voting members of the WUC. They may elect to join or not to join on WUC comments. Public comments prepared by WUC members either must have the approval of the association board or the concurrence of the board officers prior to submission. Mr. Chair, I would suggest that this would be an appropriate time for any interested party to speak concerning this matter.
Thank you. Is there anyone here representing? Okay, please take the stand.
We were here to answer questions.
Yes.
Pardon me?
We don't have a statement, you're just.
Okay, please give us your names for the record, your employer, and we will proceed.
My name is Pat Stabler. I'm the chair of the Water Utility Council at the current time, and my employer is just
Serena DiMagno, and I sit for the Waterworks Operators Association of Pennsylvania on the Water Utility Council, and I'm retired, so.
Okay. You have no prepared statement? Okay. Does anyone have any questions of these ladies? I have one on the WUC group. It says they receive no salaries. Do they receive expenses?
No.
So that 12-member group receives no reimbursement.
That's correct.
And,
except from their employers.
Right.
pardon me?
Unless the employer agrees to fund expenses.
Their employer.
Their employer, their individual employer.
They receive no expenses from the Pennsylvania AWWA.
So they have no income
Yeah, not from Pennsylvania.
from this.
From the association.
Association.
Right, okay. And are they used primarily to prepare these papers?
At the present time, it's been halted until we get this question answered.
I'm sorry to hear.
At the present time, no comments have been prepared by any Water Utility Council members until this question is answered, because we're not sure.
Okay, and under the lobbying law, you have hired the Merrick government, and they report as your principal?
Yes.
Okay, thank you.
Just to clarify, when you say they report, they are the lobbying agent for the Pennsylvania section of AWA.
That's correct.
So to the extent that they make any reporting that may be related to the activities of the WUC, that would only be in connection with, and to the extent that the WUC is a part of the Pennsylvania section, is that correct?
That's correct. That is correct.
They don't do anything directly related to your activities. You don't report to them or interact with them directly, them being Jamaica.
Well, their function actually for the Water Utility Council is basically to provide legislative and regulatory tracking. They provide fundamental information that there's a regulation coming forward. And basically the council prepares the technical response if there's any response. But as Pat said, we pretty much put everything for the last, since our original submittal to the Ethics Commission, everything has been put on hold. The council's been doing nothing in terms of responding to either legislation or regulation.
Ms. Henning?
Yeah, I just want to clarify one thing. The letter that requested the advisory, when it was talking about the association's lobbying expenses that are reported in the expense report, it included various things. And one of those was expenses incurred by what they call volunteers. So do you happen to know, were they referring to non-WUC members? They're speaking of expenses incurred by other people for lobbying purposes, or is it their view they actually are reimbursing WUC members for expenses?
No, they're not reimbursing Water Utility Council members for any expenses whatsoever. That's never occurred.
So you don't know what they were referring to there then, I guess? You have no way of knowing what they meant?
Well, for the association, it would be anything, I mean, the association has some paid staff, but primarily, everybody else is a volunteer. The entire board is made up of volunteers. So if there was some extraneous expense associated with one of those volunteers, that could be a board member. Because I'm a board member of AWWA as well. But I've never turned in an expense request. I don't think anybody else has either, but.
To the extent that anybody serving on the WUC incurs expenses, it would be something that would be paid or to the extent permissible by their employer, is that correct?
Correct,
And
yes.
their
Or
employer,
individually, yeah.
and their employer is a member of the Pennsylvania, American Water Works, is that right?
They're called a utility member as opposed to an individual member. So their employer, in order to sit on the Water Utility Council, you must be a utility member. So their company is actually the utility member. They're representing their company.
And their salary is paid for, and their participation, to the extent that it's a part of their duties, is paid for by their employer.
Correct. That's absolutely correct. And that membership rotates. That's not a static membership. It rotates through the utility members of the organization.
Utilities are elected and serve for 2 to 3 year
2 to
periods.
4 years. Something like that. Because they can read.
You can serve 2 terms and then
Yeah.
you can be reelected as a
How did this come up? You had concern that those that prepared the paper were under the Lottery Registration Act?
It came up, there was a piece of regulation that came up, and we were asking, should we prepare comments on this? And basically, our representative generic said, I'm not sure if you can prepare comments on this, it could be considered lobbying. So that sort of threw us into flummox, because it was regulations out for public comment, and we were we were representatives of our utilities, and would like to speak on behalf of the utilities, and we weren't sure if we could.
Well, the industry overall.
Or how we would handle that, how we would set up a process to, track this volunteer's time or that volunteer's time. So the question was, we should just get this answered, and then if we have to set up a process, we set up a process if that's what we want to do. But we weren't sort of seeing something's out for public comment, you're inviting public comment, and here we were representing utilities, and individual utilities could comment, but we couldn't comment as the technical or scientific entity. It just sort of seemed
Through this office, we're all volunteers, and so the question was, how do we begin to assess what our volunteer time is to prepare comments, and we just got kind of mired down with exactly what were our responsibilities relative to the Ethics Act.
You got to determine how, whether or not it would be reportable or not.
Exactly.
Okay.
Yeah.
Okay.
Yeah, reportable, and then what's the process we use to define what our contribution individually was? Because typically, the way it works is we circulate among the utility council members and essentially edit and develop the comments. And so how do you begin to formulate how to account for that process? That's really where we fundamentally kind of
That's a
stumbled.
12-person group.
That's right.
So you said it's not a static membership.
Right, there are set terms in the bylaws for how long a utility representative can serve, and then there are elections held, and a certain number of the council are up for election in any given year, and you can be elected twice, and then after that, you can't be elected a third time, and you can come back in a year or two and be elected again. So it's a rotating membership.
And it's somewhat different because I represent an organization and I've been on the council virtually from its inception.
The organizational members are appointed by the Pennsylvania AWWA board, and Synergy Water Works operators, and they're on the
She's one of the 12.
Yes.
Yes. Oh, she's one of the 18.
She's one of the 18.
One of the 18.
Oh,
There are
okay.
12 utility members, and then there's 6 others, and the 6 others are waterworks operators, PMA,
Pennsylvania Rural Water Works
Rural Water.
Association.
and an engineer's representative.
Did you say PMA, Pennsylvania Municipal Authorities Association?
And the DEP and EPA.
Right.
So just to clarify, under the bylaws, there, on the Water Utility Council, which is established pursuant to the bylaws of the PA-AWA, there are, the Water Utility Council has 18 members.
Correct.
12 of those members are utility members who are also members of the association. And 6 are non-utility members, but they must be appointed to the WUC by the association.
Yes.
By the association that they're representing.
And
By the
and
association.
the PA-AWA
Yeah.
chooses which associations.
Right.
Yes.
So 12 of the 18 serve on both boards, the WUC and the
Now,
Not
Waterworks.
necessarily, no.
I'm on the Water Utility Council, but I'm not on the board.
How many of the Water Utility Council folks are on the other boards?
It's just me.
It's just-
It's just me.
Now, are you referring to in your individual capacity, or are you talking about as you're being a representative of the member?
I'm sorry.
Your utility is a member of the PA.
Yes,
Of
Chester
the
Water
association.
Authority, a member, is a utility member of PA-AWWA.
Right.
I'm also an individual member of PA-AWWA, but the utility members, the people elected to the Water Utility Council, it's not the individual, I'm not elected, Chester Water Authority is elected.
Right.
And Chester Water Authority is appointed me to serve with that on their utility, as their utility council. So each utility is elected to the utility council, of the 12, and there's a mix of privates and authorities and municipals. There's a mix, a certain number of each on it, and the utility appoints a representative. It's the utility who's the member.
Yeah, there's a breakdown, there's representation from investor-owned, from municipal, and from authorities. So it cuts across the spectrum of the types of water utilities in the state.
But if I understand correctly, the waterworks still have employs lobbying, which is still required reporting under the Lobbying Disclosure Act, right?
Well, the PA-AWWA pays generic fees, and they are registered, but they don't engage in, they use generic, not to engage in lobbying for the PA-AWWA, but more to help in the utility council with the regulatory tracking to keep us informed.
That statement goes against what this submission said, though, because they talked about, they said primarily he does monitoring,
Yeah,
which is not lobbying, but that there may be not other activities that are lobbying. They have that in your letter, so you just don't want to contradict.
Yeah, they are, if you will, the appointed lobby entity or the association for AWWA. I don't think they don't really do a great deal of that. I think they referenced that it's under the $2,500.
So typically, it was a little, honestly, the facts were a little ambiguous in that area. But they talked about gifts and paying expenses for officials and employees, that's been reported.
What they're referring to is when we have conferences, we have state and federal officials that attend, and if there's a speaker gift, that all gets reported as it's required to be reported. That's what they're talking about.
But you're not here today to challenge that.
No, we understand that. We're just trying to get a clarification relative to the activities with the Water Utility Council.
So you're not really speaking to what the association as a whole does with respect to any overall lobbying activities that they
Precisely.
do and who they retain to do what or how it's done.
That's right.
Your
This is all-
focus is just the WUC.
Correct, yes.
Yeah, that's what I was getting at.
Yeah.
Still have that side of the,
Yeah.
This is a making comment.
any other questions, comments? Lewis?
Mr. Chair, I would suggest that we take a brief recess from the public meeting to engage in quasi-judicial deliberations in executive session before we decide this.
Okay, we will have a brief executive session, and unfortunately, the room has to be cleared. Thank you all for honoring our executive session. You want to proceed, please?
Yes. Mr. Chair, I reviewed the facts and the relevant statutory provisions. The straightforward application of the statutory definitions of the terms lobbying and administrative action indicates that the WUC's submission of written public comments on a proposed regulation prepared by a Department of State government during the public comment period of the proposed regulation would constitute lobbying, as that term is defined by the lobbying disclosure law. Also, the lobbying disclosure regulations provide that the exemption at section 13A06, parens 1 of the lobbying disclosure law does not apply to an entity such as the association, which in addition to submitting comments on the regulations, also engages in other lobbying activities. Under the submitted facts, I consider the WUC members' time to be a resource contributed to the association and expended by it. I would note that the WUC comments are submitted and controlled by the WUC and the association. It is my view that the association would be required to report the value of the WUC's members' time spent assisting in or preparing the public comment submitted by the WUC with the approval of the association. Having reviewed the manual for accounting and reporting under the lobbying disclosure law, and given that section 13A05, parens B, parens 2.1 of the lobbying disclosure law provides that, quote, a registrant may use any reasonable method of estimation and allocation, end quote. This commission may not prescribe a particular method for the association to use to value the time of the WUC members. Our opinion should note that one reasonable method would be to report the cost of such time as incurred by the respective employers. As for the question regarding Ms. Knight, specifically concerning her serving as a member and secretary of the WUC, under the submitted facts, Ms. Knight would not be considered a principal. However, the submitted facts as to Ms. Knight's lobbying-related activities are insufficient to enable a determination as to whether Ms. Knight would be a lobbyist required to register under the lobbying disclosure law. For example, the submitted facts do not indicate whether Ms. Knight's name appears on the submission of the WC's written public comments as to proposed regulations. 2, whether Ms. Knight otherwise engages in lobbying activities under the lobbying disclosure law. Or 3, in any event, Ms. Knight would fall within an exemption as provided at section 13A06 of the lobbying disclosure law. Therefore, our opinion should be limited to providing general guidance on the final question. Given my analysis, I would offer the following motion. I move that the holding of this commission in this matter be as follows. The WUC submission of written public comments on a proposed regulation prepared by a Department of State government during the public comment period of the proposed regulation would constitute lobbying, as that term is defined by the lobbying disclosure law, and would not fall within the exemption as provided pursuant to section 13A06, paren 1 of the lobbying disclosure law. The association would be required to report the value of the WUC members' time spent assisting in or preparing the public comments submitted by the WUC. Because section 13A05, parens B, parens 2.1 of the lobbying disclosure law provides that, quote, a registrant may use any reasonable methods of estimation and allocation, end quote. This commission may not prescribe a particular method for the association to use to value the time of the WUC members. One reasonable method would be to report the cost of such time as incurred by the respective employers. With respect to Louise Knight, WUC member Louise Knight would not be required to file a separate expense report under the lobbying disclosure law unless she would be a lobbyist required to register under the lobbying disclosure law, and she engages in lobbying not contained in any expense report filed by a principal or principal's representative. Mr. Chairman, that concludes my motion.
Thank you, Commissioner Lewis. You heard the motion. Is there a second? Second, Commissioner Caldwell. Any more questions or comments? I see you writing a lot, right? You will receive a copy of our order.
Thank you, you just answered the question. Thank you.
Yeah.
I wrote it yesterday.
Okay, you heard the motion in a second. No further comments? All those in favor, please say aye.
Aye.
Any opposed? Okay, the motion carried. Thank you for being here today, and you will receive an order, a written order of our deliberation.
Thank you.
Thank you. Okay, we're going to take a 5-minute intermission. And we're back, maybe a little over 5 minutes, but let's proceed with the agenda. And we will go to number 5 on the agenda, which is the Corey Mann request, and Commissioner Nick will offer up the case to the entire commission. Commissioner Nick?
Thank you, Mr. Chairman. The facts pertaining to this advisory request are as follows. The requesters are Rodney Corey, Esquire, Chief Counsel for the Republican Caucus of the Pennsylvania House of Representatives, and James Mann, Esquire, Chief Counsel to the House Republican Leader. And I would note that both gentlemen are present. This request is related to Commission Opinion 13-002. This request has been submitted on behalf of 58 state representatives, whom I shall refer to as the state representatives. The state representatives seek their own commission opinion on the subject matter addressed in Opinion 13-002, as well as additional matters. Mr. Corey and Mr. Mann note that Rule 14 of the General Operating Rules of the House permit House members to use public funds for postage and printing services, among other purposes, so long as the funds are used for any legislative purpose or function. They ask whether the Ethics Act would prohibit the state representatives from using public funds to pay what they characterize as otherwise allowable expenses for the following: postage, printing, the transmission of electronic mail and robotic telephone calls for otherwise permissible mass communication to residents of their new legislative districts, and/or the conduct of town halls, fairs, and other types of events in their new legislative districts. Mr. Corey and Mr. Mann have also submitted background information regarding the effective date of redistricting as well as the federal franking statute. Mr. Chairman, I would suggest that this would be an appropriate time for any interested parties to speak on this matter.
Yes, please. We can grab another chair for him. Welcome back.
Eric, I mean, if you want to join, I don't know what the protocol is.
You're fine, go ahead.
Okay.
My name is Rod Moore, I'm Chief Counsel of the House Republican Caucus, and I'll let my colleagues introduce themselves.
Good morning, my name is James Mann, Chief counsel to the majority leader in the House of Representatives.
Morning, I'm Ashley Grimm, I'm legal counsel to the Republican caucus of the House of Representatives.
We'd like to thank the chair and the commission for the opportunity to participate in the process today. As Commissioner Nick noted, we submitted a number of written materials as part of our request. While we don't have any formal statement to offer at this time, we wish to make ourselves available to answer questions that the commission may have. And I think that's sort of our closing at this point.
Okay,
Should we proceed?
yes, please proceed.
Your request raises a few questions. At the outset, I'd like to say that, our prior decisions, and many long before I was here, going back 20 years, indicate that members can mail outside of the district. I don't think anybody questions that. I mean, if I'm a legislator and I have a bill that allows Sunday hunting, I can write to hunters all over the state and ask them to support the bill. So a member can mail outside of the district, if it's official or legislative business. And we have not, in our opinion, really weighed in on when the reapportioned districts take effect. And there's some controversy, even within the courts, as to whether they take effect after the election or before. So having said that, in looking at Rule 14, there is no specific language that would permit robocalls, town hall meetings, or affairs, but it theoretically can be included in that catch-all, any legislative purpose or function. But in looking at it, it seems to raise some questions that hopefully you could answer. For example, I'm kind of stumbling with, in a newly reapportioned district, what would be the legislative purpose of a House member going into the district that he doesn't yet represent and have a town hall meeting in that member's district? Or what would be the purpose of a robocall into that area that would serve as a legislative purpose? I'm not saying there can't be, but I'm struggling. So maybe you can help explain a little bit how you think it would be appropriate.
Well, I can think of a couple examples, and some of them really sort of tie into Commissioner Nick, the example that you already gave with respect to a piece of legislation. So if a member is the prime sponsor of an important piece of legislation and wants to provide information, it might be something along those lines. If you're talking about something that addresses a particular problem within the county or within that area, for example, bridge repair, some of those kind of things, transportation funding really is an issue that is at the forefront these days. So the discussion of infrastructure expenses in the area of transportation funding, really any of those kind of things, any of those legislative purposes, even including updates on the legislative process as it continues, for example, during the budget cycle, some of those sorts of things. Those are really some of the examples why we might want to be able to provide that sort of communication to Pennsylvania citizens about how it operates and what's going on.
Okay, I understand. If the ethical conduct rules of the House also define mass communications, and they include robocalls and electronic transmissions in that section, but then they go on to prohibit those activities within 60 days of an election, which seems to indicate that there's some concern about these matters, whether 60 days is the automatic or the right number or not. I don't know. Earlier decisions that the commission had looked to guidance from Congress on certain things. And if you look at the congressional franking law now, they prohibit mass mailings into a reapportioned district when a person is a candidate and they do not currently represent the district. The House and the Senate have not accepted that, or at least have not included that prohibition in the House rules, which, quite frankly, is where I wish this would all be addressed in. But having said that, do you, and you're all very familiar with the Ethics Act as well as the House rules, do you see any language in the Ethics Act that would allow us to tell the House or the Senate what is an official or legislative function? And do we want to go down that path?
One thing I could add, Commissioner Nick, is that your analysis of whether something falls within a legislative purpose or is for another purpose is all about the content of that communication, the content of the act that is being performed. When you're trying to determine whether someone is engaged in a conflict of interest, and if you're looking to any language, it would probably be that, in which your examination is, what are we saying or what are we doing, and does that constitute a conflict of interest for purposes of the Ethics Act? I think that is your language.
If I could expand on that just a little bit, I think it's not so much, at least as I understand the analysis, is not so much maybe what is a legislative purpose, but in your context, what is a conflict of interest, so what is prohibited? So we're maybe not looking so much at the universe of what is a legislative purpose as we're looking at what would result in a conflict of interest. For example, the use for a personal purpose or a private meaning purpose, those sorts of things.
Well, then let me state the question in another way. Could we, do you believe that we as the Ethics Commission have the authority by regulation to establish what constitutes campaigning or political activity, whereby then going back to the Habeck case, we could say that a member engaging in those activities is realizing a private pecuniary gain? Do we, in your opinion, I'm not trying to put you on the spot, I'm just trying to work our way through this whole question. Do you think we would have the authority by regulation to define that for the purpose of determining a conflict of interest?
I don't know if it lends itself to that sort of definition in the sense that it's almost always going to be a case-by-case determination, which is what the commission has done up until this time. They've looked at the facts that appear in front of them. At least I shouldn't presume to speak for the commission, but it seems to me that the commission looks for the facts that are in front of it in a given case and determines whether this is something that crosses that line and results in a private pecuniary benefit, either to the individual or the business who's issuing the family.
I agree. I mean, in the early cases, we had a piece of material that was before the commission based on a complaint, and the commission determined that it was legislative business and the member had a right to mail outside of their district. One other question, and then I'll turn it over to the other commissioners. Under the legislative code of conduct, there's a prohibition on a member using their office for
Unwarranted privileges.
unwarranted privileges. That's my term. I'm looking for my notes. Has that ever been further pursued either by case law or anything else as to what constitutes an unwarranted privilege?
I'm not aware of any case law that's ever addressed that question. In fact, I'm only aware of one case that addresses the legislative code of ethics, and I believe the determination was that the individual, the identity of the individual blanks, I'm drawing a blank here, and I apologize for that, but the determination was that this individual was not a legislative officer or an employee, so therefore the legislative code of ethics didn't apply, and that was kind of the end of the inquiry at that point. That's the only reported case that I know of.
Thanks. Commissioner Caldwell?
Yes. If we would go a little further, would you people propose down the road that a legislator can set up a legislative office in the new legislative district that he's going to get?
I don't know if we would go that far simply because I think we enter into a number of other circumstances. I can't say that someone wouldn't want to push that envelope, but our standard practice is realistically to sign a 2-year lease. So the lease exists for that 2-year term. So I think we run into sort of practical problems to the extent legislature wanted to move out of that office and run it.
My second,
I'm sorry, Mr. Commissioner, if I could just add to that, that there are instances where it's conceivable a member might be compelled to have their legislative district outside of, or their legislative district office outside of their legislative district due to availability of commercial real estate. And let's say they wanted to ensure ADA accessibility to their district office, and the only leased premises that might be available might be just on the outside of their legislative district. That those types of things conceivably could happen.
My second question is, why doesn't your caucus do what some of the things that you want to have done? Well, why are you sending it to us? Why are you asking us to make a decision about robotic telephone calls, electronic mail, and so on? I mean, why doesn't your caucus make that decision as to whether you want to be able to do that or not? Do you have the authority to do that?
Well, I believe we do. I think the question from our perspective is simply, can we engage in those legitimate legislative mass communications in the, to use the term, quote, new district? So our question isn't so much focused on whether we can engage in this legitimate communication tool, which I firmly believe we can. It's, can we engage in those mass communications beyond the borders of the district to which the member was originally elected. And so this isn't focused so much on individualized responses to specific constituent questions or specific questions really anywhere. I mean, if someone wrote a member about a bill, they're going to get a response. That kind of thing. This has to do with the unsolicited mass mailings in those areas, and to what extent that poses any potential problem.
Last meeting, I forget the opinion that we approved for Representative Cohn. We have another one on our agenda for, submitted by Ms. Wickelman, I think, okay. And then you come along requesting the same with additional things that you want to know if you can do. Had not those opinions, the Representative Cohn opinion, been approved, would you be here today?
You know, I don't know if I can answer that, Mr. Chair, simply because I don't know as it presented itself in the same fashion. Let's say that may simply have prompted our request. We had submitted a request.
You see what I'm saying?
So it's fair. That's fair. I apologize. That's a fair question.
Pardon me?
So that's a fair question, and it may have certainly that influenced our decision to go ahead and proceed with this.
Yeah, because remember, we discussed that, and then we said as soon as we approve this, Representative Cohn's going to, every member of the House will know that. Well, then the floodgates open, and then along comes your request, not the same, the same plus additional. Right, okay. And going back to what Commissioner Caldwell said, is that our responsibility to define those answers that you're requesting? In lieu of the fact that, okay, they allowed us to do this, let's push them a little more, see if we can get that. That's kind of the perception I have. I can't speak for the rest.
If I may just comment on one thing, I tried in researching, I tried to find some indication in the House rules or elsewhere where they talk about what really constitutes a member's legislative district. I mean, is it the district that you were elected in, or once there's a reapportionment plan, is it the new district? And there really does not address it. And the only thing that even touched on it, I thought, was the expenditure guidelines of the House. And in the House Rules Committee says, and this kind of relates to what we're talking about in an office, a member may lease a mobile office for use solely within the limits of his or her district, which seems to indicate, and again, what is their district, but the district that they were elected to, that there should be some constraint on going outside of the district. Having said that, I don't know that we have the authority to tell the House that's the case. I think that's where we are.
I have some jurisdiction concerns too. I mean, it is arguable the new districts under the Constitution and the court's language, who knows? You know, maybe they are representing the newly redistricted area, maybe they're not. That's arguable. There's authority both ways. And I don't know what we're doing, telling you where you can throw your mailings. If I'm not mistaken, you know, Frank Pecora back in the 1980s in the Senate, we moved his district from Pittsburgh over to southeastern Pennsylvania. And he made expenditures. In fact, he rented an apartment down there. He was going to run as a Democrat down in that district. And the Senate addressed that through its management committee and its own financial operating rules. Why doesn't the House address this through the bipartisan management committee on a policy level?
I think we can, to the extent that the jurisdiction of the BMC goes so far, Commissioner Corrigan, but I think the issue that we would still run up against is, does this sort of mass communication, and it's really an extension, I guess is a good way to put it, Mr. Chair, the question that was asked by Representative Cohen and head on. Does that conduct constitute a conflict of interest under the Ethics Act? So, constrained to that, we're not in the same position to answer that question that the commission.
Just by way of further comment, and I appreciate and I share your assessment that so much of this, in order for the commission to give an informed decision, must be based on a case-by-case consideration, and it would help, and it does help greatly, understanding what your rules are and what your rules provide for, and even the powers of the purse that your rule provides that may in fact limit what the case-by-case analysis may be in any particular case. So the question, and it does seem, and I'm hearing the answers and in some cases not hearing the answers, but the case-by-case analysis, especially when you're going into broad-based examples that depending on the particular facts may in fact determine whether there has been a violation of a matter within the commission's purview. Maybe someone else's purview, someone else's rules, but whether or not it's a violation or raises a violation to be considered by the commission under the Ethics Act and not something broader. So I appreciate the assessment of the need for a case-by-case analysis of particular facts.
Would a House member running for Congress be able to send newsletters into the congressional district? Under your current policies and rules in the House?
Yeah, I don't believe the rules directly address it. I'm trying to remember.
I mean, that's a little more than going into the district that you're going to have next year. But I'm going to run for Congress, and I'm going to send them out into, call it the northern tier, 15 counties.
Commissioner Corrigan, if that were brought to our office, the question that we would have to address is, well, what is your legislative purpose in expanding your mailing outside of your existing district, and not even to your new district, but to 265,000 individuals, or however many, 750,000 individuals, I'm thinking Senate seat, but a House seat is 65,000 versus 750,000 people. What's the legislative purpose by going beyond?
So you would question that in the House?
We have had occasion where someone has come to us with a question of, well, can I mail this, or can I engage in this conduct? And our analysis is always the same. What is your legislative purpose? And we would apply that in that instance as well, Mr. Commissioner.
In most cases, these mailings would come to leadership because the individual House member would not have sufficient postage or expense money to do a mailing like that, so it would have to be paid for our legislative leadership council. You probably could get a chance to review it if it became problematic.
Ms. Hitty?
I just have, I'm not sure it's really a question or comment, but just to note that the commission runs into this problem in many contexts where it has to make a decision under the Ethics Act, but in order to determine whether something is authorized, it has to look at another law another set of rules. Something else is the actual source of authority of what's permitted. So for example, if they're looking at the conduct of a borough councilman, they may have to review the borough code to see if what he's done is actually allowed. Township supervisor, the township code. It isn't really a new situation. I think what is a little different here is we're actually dealing with the lawmakers themselves, the very people who define what's authorized, not only in laws, but in their own rules as a separate branch of government. And so I think that's it's especially poignant in this case where, you're coming to the commission to essentially tell you what perhaps should be more clear in your rules. If they look at your rules, will they find the answers there? Are they asked to interpret things in your rules, and maybe they're going further than they should? The precedents that are 20-plus years old was a very different context. That was people allegedly violating the Ethics Act, and a decision was reached. Does that mean the commission should suddenly go further down the path now and define for the General Assembly or the chamber of the General Assembly what its legislative purpose or official business is? Now, some things would be very clear, but when it's not very clear, is it for these people to say?
Commissioner Caldwell?
Yes, I have a question. Can your leadership authorize printing and transmission of electronic mail, or telephone calls, and other permissible mass communications to residents of the legislative district? Could your leadership make that decision for your caucus?
I think our leadership would have to make that decision if it's deemed not to be a violation of the ethics. And so I think that's why before we make decisions about whether the conduct is going to occur, we want to make sure it doesn't result in a conflict of interest for any of the members or any of the officers of the office.
It's basically a two-pronged question. Can we engage in the conduct? And the question for leadership is, should we engage in that?
Any other questions? Commissioner now? Commissioner Nick?
Mr. Chairman, I suggest that we take a brief recess from the public meeting to engage in quasi-judicial deliberations in executive session before we decide this matter.
Okay, thank you. Sorry I have to ask you to leave again. Commissioner Nick?
Thank you, Mr. Chairman. I have reviewed the facts, House Rule 14, and the relevant commission decisions. The commission's holding in opinion 13-002 followed long-standing commission precedents as the postage and printing services for mailings to new legislative districts. For the portion of Mr. Corey's and Mr. Mann's advisory request that is substantively the same as the request addressed in that opinion, it is my view that we should reach the same result that we reached in opinion 13-002. As for the rest of the request, House Rule 14 specifically speaks of postage and printing, but makes no mention of electronic mail, robotic telephone calls, town halls, fairs, and other types of events, either as to the new or the old legislative districts. The ethical conduct rules of the House do define robocalls as mass communication and then clearly prohibit them within 60 days preceding an election. Although the advisory request characterizes such expenditures as otherwise allowable, it is not within the jurisdiction of the Commission to interpret any ambiguity in the House rules. Given my analysis and comments, I would like to make the following motion. I move that the holding of this commission in this matter be as follows. The state representatives are public officials subject to the provisions of the Ethics Act. The Ethics Act would not prohibit the state representatives from using public funds to pay otherwise allowable expenses for postage and printing services or otherwise permissible mailings of items constituting official business to residents of their new legislative districts as determined by the final reapportionment plan of the Legislative Reapportionment Commission affirmed by the Pennsylvania Supreme Court. Such items constituting official business would include non-political legislative newsletters, birthday and congratulatory greetings, and notices of upcoming legislative meetings and forums as delineated in Opinion 13-002 of this commission. Under the submitted facts, Section 1103 of the Ethics Act would not prohibit the state representatives from using public funds to pay expenses for the transmission of electronic mail or robotic telephone calls for mass communication to residents of their new legislative districts, or the conduct of town halls, fairs, and other types of events in their new legislative districts, subject to the condition that such expenditures would be for official business in full compliance with the general operating rules of the House, or two, would fall within the de minimis exclusion to the Ethics Act definition of the term conflict or conflict of interest. That's my motion.
Thank you, Commissioner Nick. Is there a second?
Second.
Commissioner Corrigan? Any questions, comments? Any questions or comments? Okay, all those in favor of the motion, please say aye.
Aye.
Aye. Any opposed? Motion adopted. Thank you for coming yesterday, and thank you for coming today. Okay, moving right along. Item number 4 was also assigned to Commissioner Nick, and please proceed. The Winkleman opinion.
The facts pertaining to this advisory request are as follows. The requester is Laura Winkleman, Esquire, Chief Counsel for the Democratic Caucus of the Pennsylvania House of Representatives. Ms. Winkleman's request is substantively the same as the request we recently addressed in Longetti et al., Opinion 13-002, regarding legislative mailings to new legislative districts following redistricting. Ms. Winkleman's request has been submitted on behalf of 60 state representatives, whom I shall refer to as the state representatives. The state representatives seek to be able to reply upon Opinion 13-002 with the same status and protections afforded by law to the individuals who originally requested that opinion. The state representatives have not submitted any additional facts or questions beyond those stated in Opinion 13-002. Mr. Chair, I would suggest that this would be really an appropriate time for any interested parties to speak.
Thank you. Please state your name for the record.
Thank you, Mr. Chairman. Eric Philman, Deputy Chief Counsel for the House Democratic Caucus, on behalf of Nora Winkleman. I have no prepared remarks. I'm here to answer questions if that's necessary.
Does anyone have any questions? Please proceed.
Mr. Chairman, given that this advisory request is substantively the same as the request addressed in Opinion 13-002, it is my view that we should reach the same result. Based upon my analysis, I'd like to make the following motion. I move that the holding of this commission in this matter be as follows. The state representatives are public officials subject to the provisions of the Ethics Act. The Ethics Act would not prohibit the state representatives from using public funds to pay otherwise allowable expenses for postage and printing services for otherwise permissible mailings of items constituting official business to residents of their new legislative district as determined by the final reapportionment plan of the Legislative Reapportionment Commission affirmed by the Pennsylvania Supreme Court. Such items constituting official business would include non-political legislative newsletters, birthday congratulatory greetings, and notices of upcoming legislative and meetings conformed as delineated in Opinion 13-002 of this commission.
Okay, fellow commissioners, you've heard the motion. Is there a second?
Second.
Okay, it's moved in second. Any questions, any comments? If you recall, this is similar to the one we already had. Okay, all those in favor, please say aye.
Aye.
Any opposed? Motion adopted. Thank you. Okay, we're winding down. Thanks for your patience. Thank you.
Thank you.
Okay. The next item on the agenda is administrative payment schedules, Rob.
Robin prepared. Oh, I'm sorry, I'm sorry. Kind of zoned out there. No, there were no payment schedules during this since the last meeting.
Okay, Robin, the next one is yours.
Right. The biennial review of the FIS reporting thresholds. Commissioners who've been here recall, and for the new ones, every 2 years, we have to review the reporting thresholds for statements of financial interest to see if there's a need for change. The commission regulations provide that you're to look at the consumer price index or other relevant indices, and the commission has followed the consumer price index for as far back as I can remember. They've looked at that. There was only one time the commission did actually increase the thresholds, and that was for forms that were due to be filed in, I think it was 1997. And coincidentally, at that same time, the General Assembly was codifying the Ethics Act, and so those new thresholds were actually put into the statute after the commission had raised the thresholds. You have the consumer price index information in front of you. You did the calculations based upon the tables put out by the U.S. Department of Labor. The consumer price index has risen approximately 43% since that codified version of the Ethics Act took effect with the current thresholds. And so it's now before the commission to determine whether an increase is needed at this time. Thank you, Mr. Chairman.
Thank you. Everyone understand what this is about? In my opinion, now is not the time to change those in view of the activity for tighter pending regulations. It's not, I feel, the best interest in this commission to change those, but I'd be open to any suggestion.
Question, Mr. Chairman. And I agree with you, but a query, have we received any comments about the, on this? You know, how long it's been, have you ever reviewed them? Why aren't you raising anybody at all that has questioned us?
Not to my knowledge.
Okay.
Interestingly, back in the 90s when the change was made, there were some letters that were received. I think what the commission had initially done was they thought they would not increase the thresholds, and then letters came in from some COGS counsel. So at least at this point, we haven't heard anything. It's been on the agenda.
Council, we need a motion on this, correct?
Yes, you do.
Moved by Commissioner Colifall. May I have a second, please? Second. Commissioner Nick. Any comments, questions?
I mean, this is the motion.
Pardon me?
I don't know if we state, what's the motion specifically?
Threshold not increased.
Any questions, comments? I didn't hear.
I'm sorry, actually, just to clarify that the motions that the threshold's not being increased at this time?
Yes.
Okay.
Right. That's your motion, right? Nick? Yes. Yeah, right. Okay, everyone understand the motion? Because there's motion and second, not to increase the threshold at this time. Any question, comments? Okay, all those in favor, please say aye.
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 Any opposed? Okay, the motion is adopted. Okay, at this time, we're open to...
Chairman Walter, we did not do the meeting minutes, the approval of the minutes, number 1.
Oh, that's number 1?
Yes.
Oh, I apologize. The first item on the agenda is approval of the July 10th meeting minutes, which you have in your material. Any questions and changes? If not, I'll entertain a motion to approve those. Commissioner Nick, second, Commissioner Colville. Any questions, comments, other than chastising the chairman for forgetting that? All those in favor, please say aye. Aye. Any opposed? Minutes have been approved. At this time, we're open to any public comment that anyone in the audience has to make. If not, I want to thank Commissioner Bergen for sticking with us. Raquel, we appreciate it.
Thanks, John. Sorry I'm not there with you all.
Yeah, we miss you, we understand. And I want to thank the 3 investigators from Pittsburgh office coming. We're open to any questions that you have, or if there's anything, and we also thank you for a good job. And Attorney Harder from Robin's office, thank you. And if there's no other business before the commission, Rob will let us know when the next meeting or conference call is. This meeting is adjourned. Thank you.
Thank you.